You're going through a nasty divorce and you know your spouse is hiding assets. You toss an AirTag into the car that you both own just to see where they're going. A week later, you're the one in handcuffs, charged with a third-degree felony. I'm Rick Fletcher, a Florida criminal defense attorney. I've been tracking the legislature's every move on this, including the new Senate Bill 1168 and the local cases like State v. McManamy that show exactly how prosecutors are getting convictions. In this video, I'm going to explain the new law that makes this a felony, dismantle the owner loophole that gets so many people arrested, and give you the critical information to protect yourself from a 5 to 15-year prison sentence. As a Florida criminal defense lawyer, I see people charged with crimes they didn't even know were crimes. And right now, this is one of the biggest ones. We're talking about tracking devices, Apple AirTags, tiles, or those little magnetic GPS boxes you can buy on Amazon. It seems like a simple, harmless way to get information, but the Florida legislature disagrees. In 2024, they quietly upgraded the crime of unlawful tracking from a simple misdemeanor to a third-degree felony. And as of October 1st of 2025, Senate Bill 1168 has just gone into effect, adding even more severe penalties, and you need to know about this. Let's start with the base law, Florida Statute 934.4425. That's what makes this illegal. The rule is simple. A person cannot knowingly install or place a tracking device or a tracking application on another person's property without that person's consent. For years, this was a second-degree misdemeanor. That's the same level as trespassing or disorderly conduct. It was a max of 60 days in jail, and frankly, it was rarely prosecuted. The 2024 change. Last year, the legislature upgraded this. A violation of 934.425 became a third-degree felony. That is a 5-year, $5,000 felony. That's the same level as a possession of cocaine or aggravated assault. Senate Bill 1168, this new law, which just took effect, adds an even scarier part. It created a new subsection 5B. This new law says that if you use a tracking device to commit or facilitate the commission of a dangerous crime, the tracking itself is a second-degree felony. That is 15 years in prison. What's a dangerous crime? The statute tells us it's a long list, but the most common ones are stalking, aggravated stalking, domestic violence, burglary, kidnapping, or any forcible felony. So let's be clear. You put a tracker on your ex's car. You use it to follow them. That is stalking. You are now facing charges for stalking and a 15-year felony for the tracker you used to do it. Now, I know what you're thinking. The statute has exceptions. I'm a lawyer, I've read them. And the biggest one, the one everyone points to, is subsection 4H, the owner exception. It says the law doesn't apply to an owner or lessee of a motor vehicle that installs a tracking device on such vehicle during the period of ownership. Sounds like a perfect defense, right? It's my car, I can track it. Wrong. Let me tell you about a real case. State of Florida versus Michael McManamy out of Hillsborough County. Here are the facts. A husband and wife are married. They jointly own a Volvo. The wife files for divorce, and she also files for an injunction for protection. The husband, Mr. McManamy, puts a tracking device on that jointly owned car after she files. He gets arrested. His lawyer files a motion to dismiss, making the exact argument you're thinking of. Hey, look at section 934.425. He is an owner of the car. He is exempt, so case is dismissed, right? But the judge denied the motion. The judge's reasoning is what you must understand. The court said you can't just cherry pick one section of the law. You must read the whole statute. The judge pointed to another crucial part of the law, subsection 3, where consent is presumed to be revoked. This section says that any consent a person gave is legally revoked if one person files a petition for dissolution of marriage or one person files an injunction for protection against the other. The court's ruling in plain English was this. The moment the wife filed for divorce in an injunction, her consent to be tracked was legally gone, regardless of his name on the title. His owner status did not give him the right to infringe on her protected interest in the property. So let's apply this. Scenario number 1, a messy divorce. You and your spouse jointly own a car. You suspect they're cheating. You put an AirTag on the car. The second you file for divorce or they serve papers with you or serve you with papers, that AirTag becomes a ticking time bomb. You're now committing a third-degree felony, and that's the McManamy case. Scenario number 2, the abusive ex. A man has a history of domestic violence. He and his girlfriend break up. He secretly puts a GPS tracker on her car to follow her. He uses it to learn her new route home from work or to see if she's dating someone new. This is textbook stalking because stalking is a dangerous crime under the new Senate Bill 1168, he is committing a second-degree felony. This is a 15-year prison sentence as a penalty. But I pay the car note. The law does not care who pays for the car. It cares about ownership and, more importantly, consent. A jointly owned car is still another person's property. Another mistake people make. It's just an AirTag. The law was written to include these. The statute defines a tracking device as any device whose primary purpose is to reveal its location by the transmission of electronic signals. And that is the exact dictionary definition of an AirTag. Another mistake. I'm tracking my kid. This is a specific exception, but it's narrow. The law allows a parent to track their minor child's property. But even then, if you're divorced or separated, both parents must consent to the tracker. You can't use it to track your co-parent. Now, how to protect yourself. This is not legal advice, but here are some practical information and tips you can use. Just don't use one. The information you get is almost never worth a felony conviction. It's not. Pre-divorce removal. If you are planning to file for divorce, the smartest thing you can do is remove any and all tracking devices from all shared property before you file. If you've been served with a petition for dissolution of marriage or an injunction, you must immediately disable and remove any trackers. Legally, your grace period is now over. Now, what happens if you find a tracker? If you find a tracker on your car, your purse, or in your child's backpack, do not destroy it. It is now evidence of a felony. Take photographs, document where you found it, and take it to the police. Then call an attorney immediately to discuss filing an injunction for protection. This new law has serious, life-altering consequences. This is not a game. A decision made in anger or jealousy can now land you in state prison for 5 or even 15 years. If you have been arrested for violating Florida's tracking statute, or if you are in a situation where you fear for your safety because of someone using a tracking device against you, you need an attorney who understands this new law and the cases that define it. Now hit that like button if you learned something today, subscribe for more critical updates on Florida law, and if you're in trouble, call my office. The number is in the description below. Let's look at the facts of your case and build your defense. Thank you for watching. Stay safe and stay informed.